Time for some business news now. NCBA Bank is set to appeal a High Court ruling which nullified a 384.5 million shillings stamp duty exemption granted to the bank following the 2019 merger of NIC Bank and CBA Bank. In a statement seen by Citizen TV, the lender maintains that the exemption was procedurally secured in the interest of the public and in compliance with the law. Mbogoh now traces back the matter, which could affect how tax exemptions for mergers are scrutinized and its ramifications.
The merger between Commercial Bank of Africa (CBA) and NIC Bank, which paved the way for the formation of NCBA Bank in 2019, continues to draw attention, with the ruling by the High Court setting the stage for a fierce battle between the lender and serial litigator cum legislator Okiya Omtata, who challenged the tax waiver extended to the bank during the merger. In his petition, the senator argued that the tax waiver was never gazetted, nor was it disclosed to the public, adding that, and I quote, there was no public interest to be served by exempting the merged NIC Group PLC and Commercial Bank of Africa, which were private profit-making entities, from paying the share of transfer tax dues. A prayer that was granted by Justice Chacha Mwita, who noted that the interest exhibited in the letter from the banks seeking exemption was more private than in public interest.
Second, there having not been public interest, the decision to exempt the third and fourth respondents from paying stamp duty on the registrable instruments on the merger between the Commercial Bank of Africa Limited and the NIC Group PLC violated Article 2(1) of the Constitution.
Came our 78th branch.
However, NCBA Bank says they will appeal the decision. The lender holds that the waiver was procedurally secured and that the exemption was in the interest of the public. The bank reiterates its intention to exhaust all available legal options to uphold this position, adding that, and I quote, NCBA Group PLC's exemption application to the Cabinet Secretary in charge of the National Treasury, supported by the Cabinet Secretary in charge of Lands and Physical Planning in 2019, was made in good faith and in strict compliance with the provision of the laws of Kenya. This statement, however, presents a shift from the lender's earlier position.
But what I'll assure the public, and assure every Kenyan, is that should the court find that NCBA was not entitled to that waiver, now very clear, the day the court makes that determination that we were not entitled to that waiver, the following day we'll send a check of 350 million shillings. The following day, that I can promise.
Should the appeal fail, the lender may be required to pay the 384.5 million shillings in stamp duty, as well as potential penalties and interest. Mbogoh, Citizen TV.